The division has the right to review any advertising the developer wishes to use in promoting their subdivision. If a developer fails to comply with the requirements of the Act, the division may discipline the developer. Any purchasers may bring an action to recover the purchase price of the property plus interest within 4 years of the non-compliant transaction. Timeshare and Camp Resort Act. Before we discuss the Timeshare and Camp Resort Act, we will define what is meant by a camp resort and a timeshare in the statute. For example, some timeshares state the owner may stay in the property 2 weeks out of every year. A timeshare is a fractionalized interest in real property. According to a separate agreement, the owner of the timeshare interest only owns the right to occupy the property. The owner of a timeshare interest does in fact own real property, or an interest in real property. However, the right to occupy the real property is limited and controlled by the terms of the timeshare interest. As the name implies, a camp resort is a resort with campsites, whereon the owner may place a tent, trailer, camper, or other temporary housing facility. All timeshare offerings and camp resort offerings of property in Utah or projects marketed in Utah must be registered unless they are exempt. The following transactions are exempt from the Timeshare and Camp Resort Act. Isolated transactions by an owner of a timeshare or camp resort interest. A government sale of an interest. A pledge of an interest. An offering of less than 10 interest in a project. All covered projects must be registered with the Division of Real Estate. Sellers of covered projects must then satisfy disclosure requirements to prospective and actual purchasers of covered interest. All prospective timeshare or camp resort purchasers must receive a disclosure which contains at least the following information: details regarding the developer, including experience and criminal background; details of the property, including how many interests will be offered; details of procedures in place to protect purchasers' interests from foreclosure. The purchasers must also be given a right of rescission similar to the right to cancel the transaction discussed with the Subdivision Act. The following slide contains the statutory required cancellation verbiage, which must be in the contract. Purchaser's right to cancel. You may cancel this agreement without any cancellation fee or other penalty by hand delivering or sending by certified mail written notice of cancellation to name and address of the developer. The notice must be delivered or postmarked by midnight of the 5th calendar day following the day on which the agreement is signed. In computing the number of calendar days, the day on which the contract is signed and legal holidays are not included. An individual involved in the selling of a timeshare or camp resort interest must be registered. The statute defines selling an interest as engaging in activities to obtain commitments to purchase interest by giving presentations to prospective purchasers. Timeshare salesperson registrations are good for 1 year and are fairly easy to obtain. If an individual holds a real estate license, they may obtain a salesman registration for free. As with the Land Sales Practices Act, the Division of Real Estate administers the Timeshare and Camp Resort Act. The division also has the right to regulate any advertising of timeshares or camp resorts. Deceptive advertising is prohibited. Marketable Record Title Act. The purpose of the Marketable Record Title Act is to simplify the record-keeping and establishment of ownership rights in real property in the state of Utah. As you can imagine, tracing the ownership of a piece of property back to the original owner could be a cumbersome task. If it was necessary to trace the ownership of a property back to the original owner to verify current ownership, it would be very difficult to ever transfer valid ownership. The Marketable Record Title Act was meant to solve this problem. The Act states that if an owner of a property is able to document ownership for the past 40 years, they are considered to have marketable title. In other words, they are the owner of the property and have the right to sell the property. The owner's claim to the property must be based on a recorded document. Remember, each county in Utah has a county recorder who is charged with maintaining ownership records for all real property within the county. The Marketable Record Title Act benefits owners who have not owned their property for 40 years as well. The Act states that for any owner, one must only trace the ownership back 40 years to determine whether or not the current owner possesses a marketable title. As you can see, the Act greatly simplifies the process of verifying if someone actually owns a property. Research must only go back 40 years rather than to the original property owner. Obviously, if a completing claim for title to the property has been recorded within the 40 years prior to the date in question, the Act would not apply. The Act is also ineffective against a few other claims of ownership, including some adverse possession claims, visible easements, utility easements, and government ownership.